One of the hot topics today is the American Axle Mfg case that is currently before the Supreme Court. The question is, what should the Supreme Court do with the case? Hi, I'm George R. Meyer, and I am a patent attorney. I've learned much along my patent journey of about 30 years. With these videos, I will share tidbits that I learned along the way. Be sure to subscribe to this channel. Okay, let's turn to today's topic. American Axle Mfg versus Neapco Holdings is a very important case. The Supreme Court needs to decide whether or not it will grant certiorari to hear the case, and if it does so, how it will decide the case. In this part 4, which is the concluding part of this series, I will address this as if I was the judge. Now, I will point out some of these things are my opinions and other things are my predictions of how the Supreme Court may decide things. So keep that in mind. Now, regarding 35 U.S.C. 101, the Supreme Court really started going off the rails with Bilski. I mean, the pre-Bilski cases are very difficult to reconcile, but they're really, really difficult and bizarre and unusual now after Bilski. We're going to review a few of the pre-Bilski functional Supreme Court cases. These are the ones that were cited in the opinions in American Axle Mfg. And we're going to take a look at how was it originally decided and how should it be decided today. And really, of these pre-Bilski cases, only Fluke is a fluke, and we'll get to that in a little bit. One thing that the court has to remember, and I don't know if the people did this in their briefing, 35 U.S.C. 112F was enacted to supersede the decision in Halliburton. And this is even acknowledged by another Supreme Court case, namely Warner-Jenkinson. 112F was to strike a balance between functional claiming and limiting the claim solely to what is disclosed. So what happened was in the 52 Act, it was basically if you wanted a claim and you only wanted to recite the function without the corresponding structure or acts in the specification, you had to give the corresponding structures and acts, and you had to clearly link them to the function. Okay, let's start taking a look at our Supreme Court cases, and of course we will start with O'Reilly versus Morse. This is the famous telegraph patent case. In Claim 8, the thing to really focus on is it talks about electromagnetism, however developed. Now, there were other independent claims in this patent, but they were omnibus claims. So instead of saying however developed, they would say as substantially illustrated and described herein, or language along those lines. Omnibus claims are very narrow. Let's see how the Morse patent would fare under 112F. The actual case in 1852, keep in mind this is before we have 112F or anything similar to that. The Supreme Court invalidated the claim. Now, they gave a number of reasons why, but if we take it into the language we're using today, it was invalidated because Morse did not fully enable the scope of what he was claiming. Let's take a look at it under 112F. It's invalid because he didn't give any corresponding structures beyond what were in the specification. Because keep in mind, his other claims were limited to the structures that were in the specification. This has to go way outside it. So the claim would be likely invalidated. Now, the other claims, the Supreme Court had no problem with. Well, that's because the things generating electromagnetism were limited to what was in the specification. And assuming that those were clearly linked, those would be valid under 112F anyway, because they would be the corresponding structure. Let's take a look at another case, Dolbert versus American Bell Telephone. And this is the patent on the telephone that we think of in the old days that had a transducer that sent an analog signal over wires. Let's take a look at Claim 5. Again, notice here, as herein described. this is an omnibus claim. The Supreme Court said Claim 5 was valid because it was limited to the specification. Today, assuming you have the corresponding acts or structures linked to the functionality, it's also going to be valid. You end up with the same result. Okay, we're going to spend a little bit more time on Halliburton because this one was the one that was superseded by statute. It was for a process for determining the depth of a liquid within a well. The specification described an acoustical resonator which was used to improve the signal-to-noise ratio. Halliburton, instead of using an acoustical resonator, was using an electric filter. Now, here is part of the quoted language, and before I go into this, keep in mind that revised statute 4888 of the 1870 Patent Act included what would be today 112A, 112B, and 115. Keep in mind that revised statute 4886 include the new and useful. This was not decided under 4886. So in other words, it was decided based on any one or more of 112A, 112B, and 115. And notice, they said they invalidated the claim because the claims do not describe the invention but use conveniently functional language at the exact point of novelty. Well, guess what? That was in Chen's concurring opinion in American Axle. Now that functionality at the exact point of novelty was in an earlier case, but keep in mind, the 1952 Act, 112F, that superseded this functional language. These earlier cases were based on 112A, 112B, not on 101. And as far as functionality, they decided that functionality shouldn't be an enablement issue under traditional enablement. How did things turn out? Well, there were many claims that were at issue. The Supreme Court held that many of these claims were invalid for failure to meet the written description requirement. The specification needs to reasonably convey to one of ordinary skill in the art that the inventors actually had the invention in their possession. That's how it was invalidated. How would it be handled today? Well, we'll assume that the acoustical resonator was linked to the function. If that was the case, this claim would be valid but likely not infringed. Why? Because an electrical filter is probably not considered an equivalent to an acoustical resonator. The end result's the same. Halliburton's off the hook. Remember, Halliburton was superseded by statute. So all that functional discussion that they have in Halliburton, it's superseded by statute. Okay, let's take a look at Parker v. Fluke, and this is the oddball case. The disclosure describes updating alarm limits, and keep in mind it's for transient processes. It's huge for transient processes because these tend to be highly problematic in the chemical industry. The claim did not recite that the updated alarm limit corresponds to a transient state. So in theory, the old alarm limit and the updated alarm limit both could be at steady state. The examiner should have rejected the claim for failure to comply with the written description requirement. This is similar to Gentry Gallery. The claim should have had something about the transient state or as you are starting up or shutting down a chemical process. That's what it should have been rejected under, not 101. The Patent Office rejected the claims as being a software claim because it did not allow software claims. Well, guess what, USPTO? You were allowing software claims in 1978. You just didn't realize it. Okay, let's turn to Claim 22 in American Axle. And the thing to focus on is tuning a mass and a stiffness of at least one liner. Just for your information, dynamic tire balancing is a type of tuning. This is when you go to get your tires replaced. They take the tire off the wheel, they put a new tire on, they then put that assembly onto a machine that spins the wheel at a very high RPM, and the output that it gives is a mass of a weight and where the weight should be placed on the wheel. The operator will then select a weight, get a rubber mallet, and then pound the weight onto the wheel. That's all tuning is, so this isn't, all that complicated. The decision should be reversed. Keep in mind, this is a patent case that was dismissed for failure to comply with 101. It should be reversed because claims 22 and 26 comply with 35 U.S.C. 101. They are within a statutory class. They are a process claim. They are new, as far as we can tell. There are two modes of vibration that they're using to tune versus one mode of vibration, which was in the prior art. And, of course, it's useful because they're tuning to reduce noise. The other argument that some of the judges were making is that the claims preempt the use of a law of nature. They do not. They do not preempt the use of Hooke's law in all technical fields. Here's the problem. When you start limiting that law of nature to a field, this will become a self-fulfilling prophecy. You can always get it to a point where the field corresponds exactly with the scope of a claim. If a claim recites a law of nature or implicates it in any manner, if you limit the field to the scope of the claim, every claim that either recites or uses a law of nature will be invalidated. That doesn't make any sense. That's why the preemption needs to be in all technical fields. Now, the tuning that they describe in American Axle is going to involve more than Hooke's law anyway. And remember, dynamic tire balancing is tuning. This isn't anything really all that unusual. But the case needs to be remanded for further consideration, particularly in view of 35 U.S.C. 112, and it will need further briefing by both parties. Keep in mind, most of the pre-Bilski Supreme Court cases that were ruled on functionality were under enablement or written description. They were not called new and useful or abstract ideas, etc., etc. I didn't cover Gottschalk. I agree that Gottschalk versus Benson, that did come out correctly because it was purely math. But so many of the other ones, they're usually, and especially before 1952, they are citing what would be the equivalent of 112A enablement or 112A written description, or it could be 112B being beyond what the inventor regards as the invention. So the first question is, do the claims fall under 112F as step plus function? This could go either way. I think that it probably should not, because with the tuning they specifically recited the mass and the stiffness of the liner. What does that tell one of ordinary skill in the art? Change the mass, change the stiffness to get this vibration reduced. That should be enough. But I'm going to address enablement both ways. Okay, if 112F applies, you must enable the full scope of the corresponding structure or acts, since this is step plus function. Now, the corresponding acts, corresponding structure usually will not be a problem for the full scope. But if 112F doesn't apply, then the case law is you have to enable the full scope of what you're claiming. If you're claiming the function, 112F doesn't apply, you now have to enable the full scope of the claimed function. But remember, it's as understood by a person of ordinary skill in the art. So keep in mind, we have the Wands factors. Courts, a person of ordinary skill in the art is a whole lot smarter than you think. This would be somebody that works with drivetrains, and they would be used to how to reduce vibration along a drivetrain. In my opinion, the drivetrain includes the wheels. Keep in mind, the dynamic tire balancing is effectively a type of tuning that you're doing. They know how to do this. Okay, let's take a look at the written description real quick. If it applies, you still have to have clear linking between the corresponding acts and the function. I think that if 112F applies, this claim is invalid. I did not see any discussion of corresponding acts that were clearly linked to the function. I may have missed something, but I don't think it looks good for the patentee. But regardless, whether or not 112F applies, the claims need support in the spec and figures, and a person of ordinary skill in the art needs to be able to immediately identify the invention. And we haven't even hit the 35 U.S.C. 102 and 103 issues. Those are going to be handled separately. I personally don't think it looks good for the patent, but absolutely not because of 101. I think they are perfectly fine under 101. I think they have significant issues possibly under 112, as well as 102 and 103. And with that, we're done with this particular video. So if you like this video, give us a like and leave a comment. Remember to subscribe to this YouTube channel, or better yet, sign up for our email list at georgermeyer.com and get a freebie. Follow us on LinkedIn. Thank you for your time, and check our YouTube channel for a new video. We hope to see you soon. Bye for now.